If you are or have been working in the United States and are looking for permanent resident status or a green card through employment in the United States, it is very important that you maintain your status in the United States prior to filing for adjustment of status. In other words, prior to filing to change from your non-immigrant visa, such as your H-1B or your TN, over to the green card. If there are any violations in your immigration status, it could prevent you from getting that green card. But it is important to remember that there are certain exemptions that are in the Immigration and Nationality Act that won't prevent you from getting your green card despite some minor immigration violations. And there are certain criteria that must be met in order for this to work. For example, you must have been lawfully admitted to the United States. And if you were admitted to the United States and you had an immigration violation such as you worked unauthorized or you overstayed your work visa for no more than 180 days since your most recent lawful admission, you may be able to still adjust status in the United States despite that visa overstay or despite that unauthorized work. And that's an aggregate period since your lawful admission to the United States. Prior violations do not count. For example, if you had a immigration violation, you overstayed, maybe you were here as a student, you overstayed multiple days, you left the United States, and then you came back in as a worker, that prior overstay will not count against you. So previous violations are ignored. So this only counts since your last lawful admission to the United States. And if you meet this exemption, and your violation was less than 180 days, then you might be able to still adjust status in the United States despite unauthorized work or overstaying your visa through petition from your employer to change to a green card.